Hello, everyone. Thank you so much for joining us today. I am Nancy Murr with Ollie at Berkeley and have the distinct pleasure of introducing today's speaker, William Bennett Turner. A little bit about Bill. Bill taught First Amendment courses here at Berkeley for 3 decades. In law practice, he argued 3 cases before the Supreme Court and many, many more cases in federal appellate courts and state Supreme Courts. Bill is a graduate of Harvard Law and the recipient of a Fulbright Fellowship. He spent 10 years with the NAACP Legal Defense Fund. And as he told us in an interview several years ago, he was assigned to represent prisoners who had no civil rights. The government censored what they could write and what they could read. And it was at that point he really immersed himself in the First Amendment. And that led to his first 2 cases before the Supreme Court. Bill is the author of several books, including his most recent, Free Speech for Some, How the Supreme Court is Weaponizing the First Amendment to Empower Corporations and the Religious Right. So before I turn things over to Bill, just a little bit of housekeeping. Bill's gonna speak for about 45 minutes. If you have questions during that time, please just pop them into the chat and then we'll get to your questions after he's done with his talk. So Bill, without further ado, the Zoom screen is yours.
Thanks very much, Nancy. It's great to be back at Ollie. Even on Zoom, you're looking good. And today I'm going to be talking about defamation and disinformation, which seem to be kind of hot political topics these days. As long as there are humans, there will be defamation and disinformation. That is, some people are always going to tell lies about other people, and some people are going to tell lies about the issues of the day. But now defamation and disinformation have become major political issues. They're close cousins, defamation and disinformation. They both involve false speech. Defamation, in simplified terms, is publishing a false statement that injures a specific person's reputation. It smears your good name. Disinformation is not necessarily aimed at a particular person, and it doesn't necessarily cause harm. Unlike defamation or libel, which is the written form of defamation, disinformation is not a legal term at all. In our current political and culture wars, conservatives and liberals are not surprisingly divided over what to do about both defamation and disinformation. Remember, during the 2016 presidential campaign, Donald Trump said, as president, he would, quote, open up the libel laws and make a lot of money suing the media. He condemned the mainstream press as enemies of the people. They put out fake news. Conservatives think they don't get fair treatment by the mainstream press, and they've now embarked on a campaign to restrict its power and influence. On the other hand, the liberals want to protect the mainstream media's right, without getting sued for libel, to criticize politicians like Trump. As for disinformation, conservatives want to punish the social media for kicking their users off their sites because of their political views. They claim that's, quote, censorship or cancel culture. And Trump, of course, himself was kicked off of, at least temporarily kicked off by Twitter and Facebook and YouTube. Liberals don't seem so concerned about being censored. Rather, they want to require the social media companies to police their sites and root out hate speech and anti-Semitism, extremism, white supremacy, and violence. So to untangle all these issues, let's look first at the history and the current disputes involving defamation, then the extent to which false speech is protected by the First Amendment, and finally, proposals to restrict disinformation on social media. So on defamation, we were treated last year in 2022 with to the spectacle of several high-profile libel trials. Sarah Palin lost her case against the New York Times. She claimed that an editorial falsely accused her of inciting the shooting of Gabby Giffords. The actor Johnny Depp won his suit against Amber Heard. She had written an op-ed piece saying that she was the victim of Depp's domestic abuse and violence. Donald Trump was both a libel plaintiff and a libel defendant. He sued the New York Times. The case has gone no place. And was sued by one of the women he allegedly raped, E. Jean Carroll. He called her a liar. And that case is now, I'm sure you're aware, in trial in New York. Oddly enough, there are a few cases, extremely rare, in which liberals cheer for media defendants to lose. In what had been called the Super Bowl of libel, Dominion Voting Systems sued Fox News for airing and amplifying Republican conspiracy theories that voting machines were rigged to change Trump votes into Biden votes. Some liberals were disappointed that Fox avoided an embarrassing trial by a last-minute settlement of $750 million. Well, defamation used to be only a matter of state law and didn't raise any First Amendment issues at all. It was simply a category of speech, yes, like perjury or obscenity, yes, speech, that had no First Amendment protection at all. But in 1964, the Supreme Court constitutionalized the law of libel, making every libel case a First Amendment case. That was in New York Times versus Sullivan, which is the Roe versus Wade of free speech. It's worth remembering what happened in the Sullivan case. The Times published in 1960 a full-page ad headlined, "Heed Their Rising Voices." It was a fundraising appeal for Dr. Martin Luther King's campaign for civil rights in the South. And the ad was signed by dozens of civil rights activists and celebrities, including the late Harry Belafonte, Marlon Brando, Jackie Robinson, and even Eleanor Roosevelt. The ad focused on Montgomery, Alabama, and described the brutal police suppression of student demonstrations there. It alleged that Dr. King had been arrested 7 times by Southern violators. The police had not only mistreated student demonstrators, but they had bombed King's home and arrested him a bunch of times and so on. Some details in the ad, like the number of arrests, for example, were not entirely accurate. L.B. Sullivan was then basically the chief of police of Montgomery, Alabama. This is the only picture that I've ever been able to find of L.B. Sullivan. He wasn't mentioned in the ad at all, but he testified in the case that when he was shown the ad, he was definitely not a New York Times subscriber. He felt that the references to police misconduct implicated him. So he sued the New York Times for libel, seeking $500,000 in damages, which was big money at the time. The all-white, all-male jury brought back a verdict for the full amount, $500,000, that Sullivan had asked for. Well, the Times, not surprisingly, appealed to the Alabama Supreme Court, arguing that the judgment in the case violated the paper's First Amendment rights. The court affirmed the judgment, the Alabama Supreme Court, completely rejecting the paper's constitutional argument by saying accurately that libel had never been thought to raise any First Amendment issues. Against long odds, the Times sought review by the United States Supreme Court. And in a masterful opinion authored by Justice William Brennan, the court unanimously reversed the Alabama judgment. In a sense, Brennan's opinion was an originalist opinion before that became fashionable. The Justice Brennan went back to the framers of the Constitution, principally James Madison, the author of the First Amendment, and Brennan reported, in his opinion, that Madison had reasoned that democracy is premised on every citizen's ability freely to debate and criticize government and its officials. Since political speech needs, quote, breathing space, and mistakes are inevitable in the rough and tumble of public debate, some false speech has to be tolerated, or some true speech will be suppressed. In reviewing our free speech history, Brennan said in the most famous quote from the decision, "We have a, quote, profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. And that may well include mistakes and falsehoods." Brennan said that political speech doesn't lose constitutional protection just because it's false and defamatory. That's a lesson, he said, that the nation learned from our experience with the infamous Sedition Act of 1798. That law made it a crime to defame the president or either house of Congress by publishing, quote, false, scandalous, and malicious accusations about them. Under that law, 14 editors in various colonies and states were convicted and jailed under the act. None of their cases reached the Supreme Court because the law expired by its own terms when Thomas Jefferson was elected president, and Jefferson promptly pardoned all of the editors. He later explained, quote, "I considered and now consider that law, the Sedition Act, to be a nullity, as absolute and palpable as if Congress had ordered us all to fall down and worship a golden image." The court in Sullivan quoted Jefferson, noted that Congress had acted, they had voted compensation for the editors, and concluded that the Sedition Act had been condemned, quote, "in the court of history." It declared that the central meaning of the First Amendment was that we all have the right to criticize government, even if our criticism is not entirely true. The court held that there's no such thing in this country as seditious libel on government. Brennan then announced a new constitutional rule for suits by public officials. They can recover damages for defamation only if they prove statements about them are false, and it's the official's burden of proof on falsity, and the statements are made with what Brennan called actual malice. The actual malice standard, as invented by Brennan, has nothing to do with malice as we normally use the term. Instead, Brennan defined it to mean the statement was published, quote, with knowledge that it was false or with reckless disregard of whether it is false or not. The plaintiff doesn't have to prove the publisher intended to defame the plaintiff. Rather, the question is what the publisher thought or knew about the truth. That was in 1964. A few years later, 1967, the court extended the Sullivan reasoning to require public figures in addition to public officials to meet the actual malice standard. These are people, the court reasoned, who don't happen to hold public office, but who enjoy power in our society and who have ready access to the media to counter any defamatory material that's published against them. Think Elon Musk, for example, or Oprah, or Steph Curry, or online influencers. They're all public figures who have to prove actual malice in the same way that public officials do. Well, it's the actual malice rule that has incurred the wrath of political conservatives, including Sarah Palin, who lost her case precisely because she failed to satisfy the rule. They don't want to give conservatives, they don't want to give the mainstream media constitutional immunity from liability for publishing untruthful information. Ironically, the actual malice rule was the heart of Fox News's unsuccessful defense in the Dominion case. Leading the charge against the conservative campaign is none other than Justice Clarence Thomas. Justice Thomas undertook long-term attacks on abortion and affirmative action and gun control. Precedent be damned. He has launched his own campaign to overrule Sullivan. In 3 recent opinions, he has, starting in 2019, he has called for the court to, quote, reconsider, that's code for overrule, Sullivan. Thomas, in the 2019 opinion, brazenly disparaged Sullivan and cases following it as, quote, policy-driven decisions masquerading as constitutional law. He complained that Sullivan did not attempt to base the actual malice rule on the, quote, original understanding of the First Amendment. He noted there's no mention of actual malice in the amendment and said, quote, if the Constitution doesn't require public figures to satisfy an actual malice standard, then neither should we. And he then repeated these contentions in 2 other recent opinions. The conservative campaign led by Thomas is not a modest law reform effort. It's crassly political. It's not inspired by a concern that the law should do a better job of preserving the reputations of individual citizens. Rather, it's motivated by right-wing grievances against the mainstream media, like the New York Times and the Washington Post, which conservatives complain are run by left-leaning, Ivy-educated, coastal elites who are biased against their viewpoints. The trash Sullivan agenda was unmasked promptly after Thomas lost his campaign, when an influential judge on the District of Columbia Court of Appeals, Lawrence Silberman was his name, said that the mainstream media bias against the Republican Party was, quote, shocking. The Times and the Post, naming them, are, quote, virtually Democratic broadsheets, and nearly all television, network, and cable is a, quote, Democratic Party trumpet. He said that because the Sullivan rule, quote, serves only to enhance the press's power, it is a threat to democracy and should be overruled. Well, now Neil Gorsuch, Justice Gorsuch on the Supreme Court, has joined the attack. He added his opinion to one of Thomas's, but he took a different approach. Gorsuch pointed out that the media landscape has seismically shifted since the time of Sullivan, and there's something to this. More than a quarter of the nation's newspapers have folded since Sullivan. Fact-checking and editorial oversight are disappearing. Now anybody can publish on social media, and the social media companies will, according to Gorsuch, quote, monetize anything that generates clicks. It's a world in which everyone carries a soapbox in their hands, but the actual malice rule is an effective immunity from liability. Gorsuch added that if informed democratic debate is the goal, why encourage falsehoods in quantities that nobody could have envisioned at the time of Sullivan? Gorsuch didn't mention any of the lies peddled online by his benefactor, Donald Trump. The conservatives on the court may well be able to muster 5 votes to reconsider and overrule Sullivan, thus encouraging more defamation litigation against publishers, mainstream or fringe, left-wing or right. That would be regrettable. Sullivan has been settled law for well over half a century, and you certainly don't want to tinker with the central meaning of the First Amendment, its protection for criticizing public officials and its prohibition of seditious libel. We don't want to be like China or Russia, where you can be imprisoned for insulting the authorities. And note that while Sullivan is often thought of as a freedom of the press case, Justice Brennan did not rely at all on the press clause of the First Amendment. Rather, his reasoning was that we, the people, as citizen critics, all of us, have free speech protection against being sued for venting our views. Sullivan should not be sent the way of Roe versus Wade. Well, what about the First Amendment? Sullivan is not the only case in which the court decided that falsehoods can enjoy First Amendment protection. False statements may have no First Amendment value. That is, they don't further the search for truth or contribute to the marketplace of ideas or promote democratic self-rule. These are reasons why we protect free speech. But the court has refused to treat false statements as a category of speech, again, like perjury or obscenity, that has no First Amendment protection. Falsity alone, according to the court, does not mean no First Amendment protection. under well-recognized First Amendment principles, if a law prohibits speech based on its content, what is said, not where or when, but what is said, the court has to give, quote, strict scrutiny to the government's reasons that supposedly support the law. That's usually the death knell of a law, as very few such laws survive that kind of scrutiny. And the court regularly invokes the principle that, quote, the remedy for speech that is false is speech that is true. The remedy for bad speech is not suppression, it's good speech. So, is there a constitutional right to lie? What a wonderful country we live in, a constitutional right to lie. That's the wrong question. The court has not decided that the Constitution affirmatively gives us a right to lie. Rather, the court has ruled that the government power over what we say is limited by constitutional principles. We don't trust the government to police our public discourse and make sure we are always truthful. The court has scorned the idea that we should be governed by some kind of Orwellian 1984 ministry of truth. The First Amendment stands, therefore, as a significant barrier to government attempts to ban false and offensive speech. The court has, over the years, struck down laws restricting Ku Klux Klan speech, an anti-Semitic rant, a Nazi parade in Skokie, Illinois, homophobic anti-Catholic demonstrations, and racist trademarks. The court has made it plain that there is no hate speech exception to the First Amendment. That kind of speech may be awful, but it's lawful in the sense that the First Amendment shields it from prohibition. Most of the lies that concern most people, racist, medical disinformation, election fibs, extremist rhetoric, are legal in the sense that the liar, like George Santos, for example, is not subject to prosecution. Okay, let's talk about disinformation. Been with us a long time. Some kinds of disinformation, like government propaganda, are of ancient origin. But these days, disinformation issues mostly involve social media, like Facebook, Instagram, Twitter, YouTube, TikTok, and so on. Exhibit A, again, is Donald Trump, who tweeted his big lie about a stolen election over 400 times from the 2020 election to January 6th. He convinced a lot of people. The disinformation problem is primarily a product of the internet and what some people call cheap speech. It's what Gorsuch talked about. You don't need a printing press or a broadcast license or even a high school diploma to be a publisher. At little or no cost, you can distribute your own views or your fellow travelers' views to tens, hundreds, thousands, or millions of people all over the world. Both political sides agree on one thing. Social media have too much power to affect the national discourse. The companies can delete posts that they don't like. They can amplify the posts that they do. They can refuse to allow you to post anything. They can deplatform you. It's an interesting word, deplatform you, without any accountability. They can engage in content moderation, watching out what people say or don't say online, or they can choose not to. their actions affect election outcomes, public health, race relations, and other issues. Well, in considering how to limit this power that the social media have, it's vital to remember that these are private companies. They're not the government. The First Amendment, though, binds government and government alone, not corporations, not labor unions or churches or any other private entities. It does not apply to social media platforms. They definitely can abridge your freedom of speech on their site, but that doesn't violate the First Amendment because, again, they're not the government. You know, it's not well known that Apple and Google, through their app stores, impose their own content moderation on the social media platforms. So if a platform like Twitter wants to do business on iPhones, which is essential, it has to comply with Apple's guidelines for app developers. The guidelines say that Apple will reject any app that doesn't have a way to filter, quote, objectionable material from being posted. The guidelines say an app can't include content that is, quote, offensive, insensitive, upsetting, intended to disgust, in exceptionally poor taste, or just plain creepy. By the way, if the government tried to impose any such rules, they would be laughed out of court as blatantly unconstitutional. Platforms that violate the Apple guidelines, and Google has similar ones, are subject to being kicked off, which would be catastrophic for the developers for the social media, since phones are the way that most people use the social media. If Apple were rigorously to enforce its guidelines, that would effectively root out at least some awful content. Well, what can government do about the power of social media? There are plenty of proposals, both in Congress and in the states. What I call transparency statutes could make a difference. Several laws have been enacted and bills have been introduced that require the big social media sites to disclose their moderation policies, to publicly report on how they enforce them, to publish their takedown policies and their statistics, to give users who get kicked off or who get labeled a right of appeal, and to have employees available to answer questions about all of the above. That's basically the approach of a new law in California, a bill introduced in Congress, and Texas and Florida laws that passed last year and that are now pending in the federal courts. The new California law, AB 587, requires social media platforms to publish in minute detail the nuts and bolts of their content moderation policies, and it requires them to state publicly whether they monitor hate speech, extremism, harassment, and disinformation. And mischievously, in my view, it makes the platforms themselves define those terms. It's a very nosy law, but it doesn't prohibit speech of any kind. On the federal level, the Platform Accountability and Consumer Transparency Act, the PACT Act, which has not passed, is very similar. And then there's the Texas law, which was backed by Governor Greg Abbott as part of the conservative agenda. And it has disclosure obligations of the kind in the California bill, but it adds a substantive provision making it illegal censorship to reject a post based on its viewpoint, which would mean anything political. The law was immediately challenged by the industry, the social media industry, when it was enacted, and a federal court enjoined the enforcement of the Texas law. The Supreme Court case went quickly to the Supreme Court on a stay, and the court 5-4 kept the law from taking effect until the appeals process is concluded. Then the Court of Appeals for the Fifth Circuit upheld the Texas law. Meantime, a similar Florida law championed by Governor Ron DeSantis was struck down by a different Court of Appeals, and it's in their certainty that the Supreme Court will have to deal with this conflict in lower court rulings. Transparency laws, assuming they survive judicial scrutiny, seem to be a useful first step in dealing with disinformation and an experiment to see what works and what doesn't. If nothing else, the data that produced by disclosures would give legislators some guidance for deciding whether and how to enact other regulations. And then there is Section 230 of the Communications Decency Act, sometimes called the Magna Carta of the Internet, sometimes called 26 words that created the Internet and the legal backbone of the Internet. It protects the social media from civil liability for publishing content posted by their users. For example, if a Facebook user defames you, you can sue the user, sure, but not Facebook. Section 230 was enacted in 1996, near the dawn of internet communication. The Section 230 immunity made possible the business models of the social media and greatly facilitated the growth and development of the internet. It has served its purpose and made the big tech companies enormously wealthy. Section 230, though, doesn't give the companies any incentive vigorously to police their sites. Indeed, it enables the sites to make more money by amplifying and spreading disinformation without fear of liability for the harm caused, without accountability. Section 230 has become politically unpopular as the social media becomes so powerful. Politicians of very different ideologies, like Joe Biden and Donald Trump, both of them during the 2020 campaign, favored outright repeal of Section 230, and a lot of other people favored various kinds of amendments, some encouraging content moderation, some eliminating it. Mirroring his attack on the Sullivan rule, Justice Thomas has already inserted himself into the debate, handing down 3 opinions, criticizing expansive lower court interpretations of the law and saying, ominously, the court should pick a case to decide, quote, the correct interpretation of Section 230. Conservative hostility to Section 230, like their hostility to Sullivan, seems to be based not on any articulated need for reform, but on a desire to punish big tech for having ousted some right-wing users and blocked or labeled conservative posts. This February, the Supreme Court, 2 months ago, Supreme Court heard its first Section 230 case, Gonzalez versus Google. The family of a woman who was murdered in Paris by ISIS operatives sued Google for wrongful death because ISIS was allowed to post recruitment and training videos on YouTube, which is owned by Google. In its defense in the case, Google invoked Section 230. In response, in the Supreme Court, the Department of Justice argued for an interpretation of the statute that would protect Google and similar companies from liability for their, quote, hosting activity. For example, routinely allowing a user to post, but would not be protected from liability for their amplifying activity, that is, promoting a post to others, suggesting related posts. If you like this, you like this, and so on. Google warns in their brief in doomsday terms that if platforms lose their immunity from liability for organizing posts and making recommendations, quote, the internet would devolve into a disorganized mess and a litigation minefield. The court will decide the scope of Section 230 in this case by the end of June, the next 2 months. Upholding social media liability for amplifying harmful speech, but maintaining Section 230 immunity for simply hosting user-generated content, that's a possible compromise. However, if the goal is accountability, Congress should go ahead and forthrightly repeal Section 230. There's no persuasive justification why these big corporations should be singled out and favored over other businesses who can be sued for damages when their products cause harm. There's no good reason why they uniquely should be exempt from liability for harm that they in fact cause. Nobody can be sure what would happen to social media if the Section 230 were repealed. It's unclear how the industry would be restructured, but it surely would be. When I couldn't find any definitive answer to that, I decided as an experiment to try artificial intelligence. I looked up ChatGPT, which just came out a few months ago. And well, it's better than Siri. And I asked ChatGPT what would happen if Section 230 was repealed. And within seconds, it wrote me an answer saying companies like Facebook and Twitter would be exposed to, quote, increased risk of lawsuits over things like defamation, harassment, and hate speech, unquote. That's pretty obvious. My chatbot also said that repeal would, quote, potentially lead to more censorship and self-regulation by these companies. Well, potentially is, of course, a weasel word. And then the bot concluded by saying appeal, quote, could make it more difficult for smaller platforms and startups as they, quote, may not have the resources to handle the legal burden of moderating user content. So we still don't know how the industry would respond. Removal of Section 230 immunity would not, in my view, mean automatic liability in any particular case. The companies would still have all of their other defenses available, and claimants would have to prove all of the elements of their case including, for example, in defamation claims, Sullivan actual malice. The companies could still block posts that they thought would risk liability, and the repeal could be made effective in a couple of years so that the companies would have time to adjust their business models and algorithms and get used to the idea that they would have to do a much better job of blocking defamation and disinformation. Well, it's likely that most of us are not so worried about being kicked off a site or censored. And we're more concerned about other people's lies being published, amplified, believed, and acted on. It'd be nice if the government subsidized media literacy courses in schools that would educate citizens to identify trustworthy sources and avoid being duped by false and misleading posts. It would be better if the law balanced freedom of speech with reasonable accountability. It would be best if people didn't lie. So, to sum up, political conservatives and liberals both want to deal with false speech, but in very different and inconsistent ways. Conservatives want to abandon Sullivan in retaliation for what they view as the mainstream media's unfair criticism of them, and they want to punish social media for restricting their own speech. Liberals want to keep Sullivan's protection of the right to criticize public officials and figures and restrict social media from publishing and amplifying dangerous disinformation. Each of these issues requires political resolution. Good luck with that. So if there are questions, let's see what's going on here.
Bill, thank you so much for that. And so what do you anticipate the decision will be in June?
In the Section 230 case in the Supreme Court, I think the court may well find a compromise. It may be the compromise that's that the government suggested. That is liability, no liability for simply posting what users themselves had to say, but liability for when they promote, recommend, post and amplify them to others, and those in fact cause harm, then liability might result. It's all about an interpretation of the law. It's not a First Amendment case. It's simply a construction of the statute.
I mean, those algorithms are the magic potion behind everything. So we do, unsurprisingly, have questions in the chat. The first one came from Jim, who asks, is there a definitional boundary between disinformation and selective reporting of facts? Is this the difference between bias and disinformation?
Yeah, well, disinformation may be the broader term, and being selective about what facts you report and so on could be a kind of disinformation. But neither of those terms has any legal significance. Disinformation is not a legal term, and selecting which facts you choose to report. It's just a description of what may or may, what definitely does happen in every news story that is reported. Somebody's decided what to report and what not. That may have legal significance, but it's not a legal term.
Okay. A couple of questions have come in about how other countries and regions deal with libel and defamation. So the first one is from Bruce. asking about Canada, our neighbor to the north. Do they hold news media to a higher standard than we do here in the
Yes, yes, they do, in the sense that they don't have Sullivan. They do require, as I recall, I'm not up to the minute on Canadian law, they do require some kind of fault by the publisher of untruthful information before liability would be imposed. But it is not, as I recall, actual malice as required by Sullivan. Our Constitution, our First Amendment, as interpreted by Sullivan, is the most protective in the world of media misstatements and falsehoods. Great Britain is much more restrictive, and it has been viewed until fairly recently as a haven for libel suits, so that people who happen to be defamed everywhere worldwide would choose to sue in England, where there are not these protections for the press, rather than in the United States, even though most of the damage might have been done here.
Okay.
Britain is getting a little more protective in recent years, and the European Union is pretty much like Canada and the UK.
So the onus falls more on the institutions and organizations rather than on the person making the accusation. Is that right?
Well, I'm not sure I
Meaning
the-
is English laws are more favorable to someone looking to protect their reputation.
Yes,
that way.
exactly. They don't have to show actual malice. And, you know, our law of libel is directly the descendant of English common law. The law in the United States was English common law until we became a country, and all of the new states decided to adopt the common law of England as their own law. And that law included libel. And in England, at the common law, and until New York Times versus Sullivan, the burden of proving the truth was a defense on the defendant. And the Sullivan case flipped that and made it harder on the plaintiff to win a libel suit because they have to prove falsity. Which it appears that, for example, that Dominion did in the Fox News case. The judge was satisfied, at least, that a number of the things that Fox News aired were in fact false. So that the issue in the case then would be actual malice, and rather than risk losing that, Fox News ponied up a lot of money.
Yeah. Wendell asks, and you've already touched on this, but maybe you can elaborate a bit more on European laws with their history that criminalize the denial of the Holocaust, for example. And
yes, some countries, Germany prominently, make it a crime to contend, to say that the Holocaust did not exist, was a hoax. That's a crime, and it's treated criminally. Even if it was civilly, it would not be tolerated under American law. There's no law in our country that says you can't say that. And if there were, it would be held unconstitutional as a violation of the First Amendment, using the analysis that the court has repeatedly used in a number of cases in recent years, which is, as I mentioned, if a law restricts speech because of its content, as the anti-Holocaust speech law would do, then the court applies strict scrutiny that requires the government to prove that the restriction on speech serves a government interest of the highest order, a compelling government interest, and does so in the least restrictive means possible, which is a very hard test for the government to make, and it usually loses a case when it tries to defend a content-related restriction on speech.
Let's see, Bob Brewer makes a comment, but elaborate, please, share your thoughts as well, that it strikes him that transparency laws come dangerously close to compelling speech by social media companies.
More than dangerously close, they do compel speech, but they are disclosure laws, which are a little different from the government dictating what you have to say. We have all kinds of disclosure law, the FDA and Securities Act requirements and so on. We have all kinds of disclosure laws, and the court is more lenient with regard to required disclosures than it is to outright compulsion to say things that the government wants you to say. But that would certainly be a major issue in the constitutionality of any of these transparency statutes. It's an astute observation that what Bruce or whoever it was said.
Bob. Bob Brewer. A shout out to Bob Brewer. Newton Fong has two suggestions, and let's get your take on that. The first one is bring back the FCC fairness doctrine, which is, he elaborates, dealt with presenting balanced points of view on matters of public import. And so that's one. So we'll want your take on that. And number two, expand the equal time rule for just radio and TV broadcasting stations to today's social media platforms. But number one, so fairness doctrine, what do you think?
Okay, well, the fairness doctrine, just to refresh your memory on it, was an FCC invention dating way back to the early days of broadcast, back to the 20s, that required licensed broadcast stations, then radio, and soon thereafter television, to do two things: to cover the issues of the day, and to do so in a fair way, fair and balanced, as Fox News used to say, way, in the sense of giving voice to contrasting points of view. And that law was not really very rigorously enforced by the FCC. And then in the Reagan administration, you remember that one of his big policy changes was get government off the backs of business, deregulate. And the broadcast industry persuaded the Reagan administration to criticize and then abandon the fairness doctrine. And in 1987, the Reagan appointed FCC abandoned the fairness doctrine, and we haven't had it since. Note that the fairness doctrine applied only to licensed over-the-air broadcasters, radio and television. Did not apply to cable, did not apply to satellite, and certainly didn't apply to the social media, which didn't exist at the time. It had some usefulness, and Congress has attempted to resurrect it unsuccessfully a couple of times. The Bush presidents threatened to veto it, so it hasn't been resurrected. I don't see how it could possibly be applied to the social media. You and I and every other user of social media would have to give voice to views that conflict with our own, that we would be required to go on social media and say, well, here's what I think, but somebody else thinks I'm wrong, and here's why. That just seems preposterous to me. So I would not foresee a resurrection of the fairness doctrine. And these days, why bother with it when social media is where the action is, not broadcast and cable? So then the other
was the equal time rule,
applied
to social media, and again, hard to see how.
That bites on licensed broadcasters again.
Yeah.
And licensed broadcasters have to give equal time during election season. to all of the candidates. There are exceptions to it. But again, it would not work on social media. You can't require everybody who's on social media
Yeah.
to give equal time to all the political candidates.
And we're out of time, but Jim has, Diesel has another interesting point, and then we'll need to wrap up. You know, on social media, you aren't necessarily required, depending on the platform, to use your real name. Do you think that when people operate with the knowledge that speech has consequences, including lawsuits and so forth, that a requirement to use your real name on social media might help alleviate some of that?
Yeah, I think it would. Certainly people would have, if they have to identify themselves as speakers, they would be much more cautious about what they say. That's obvious.
Yeah.
If government were to require identification as a condition of use of social media, that would present constitutional problems, because the court has said that there is a right to speak anonymously.
Mm.
But if the social media themselves decide that we're not going to post anybody's whatever they want to say unless they accurately identify themselves, they're entirely free to do that, because the First Amendment doesn't apply to them.
Yeah. Well, Bill, thank you so much. We are out of time and a little past time. We are recording this, and as soon as we get it captioned, which will be in about a week or so, we'll share it with all the registrants of the talk, as well as post it on our YouTube channel. So look for it in your email, everyone, and head on over to our YouTube channel where you'll find this, and then all other previous talks at Ollie. So Bill, thank you so very much. What a really fascinating and important talk.
Thank you.
Thank you. Thank you, everyone.